Privacy Forum, Dublin City University webinar and discussion on a important and timely topic. Delighted to have a really fabulous group that I will let our leaders here introduce to you. We'll be watching the chat and taking questions as well. I'm Jules Polonetsky and I'm joined by Edoardo Celeste at DCU. I will hand over to Edoardo and simply say that we thought this was a particularly good topic to start with and to do in Dublin. Clearly, we're seeing a very significant number of senior data protection officers being added, being trained, being staffed at a range of companies across every sector in much of the world, in much of Europe, and particularly in Ireland in particular. And so we've seen some of the challenges of new people coming into the profession because there's such a demand. We've seen very senior people who are detailed experts and who've played roles sometimes really advising and giving legal advice and who are readjusting to put on the more independent role of the DPO and really thinking through what does that mean from their previous role as an advisor. Is there really a world of two hats being worn here? Obviously, we're seeing decisions that are taking great care to draw the lines. And I think as this new, relatively new, at least new to many staff, to many countries, role becomes more established, there's a lot we all need to learn, both from the regulators who have set the tone for it, as well as for those in practice. How is this working? Are DPOs in government agencies are outside DPOs? Is this living up to the goal that the legislators of the GDPR intended? And how can we all make sure we're bringing the both expertise and independence that we wish? So I'll get out of the way. Edoardo, thank you for joining and for co-hosting, and we'll get into the action.
Many thanks, Jules, and hello everyone. My name is Edoardo Celeste, and I'm lecturer in law at Dublin City University. I'm really delighted to officially open this webinar co-organized with the Future of Privacy Forum. In 2020, indeed, DCU celebrates its 40th anniversary, and from the outset, our university has been characterized by a focus on innovation and close engagement with the enterprise sector in its research and in our research and education activities. And last year, we launched the first multidisciplinary master program in Ireland in the area of privacy and data protection law. And its peculiarity is to provide students with an expertise in both law and computing. In this way, in my opinion, significantly enhancing the knowledge and the employment opportunities of our students. The program is open to students having background in law and computer science and offers the possibility to be taken part-time over 2 years. So thanks to the work of my colleagues, Dr. Rob Brennan and Dr. John Quinn, we have recently signed a memorandum of understanding with the Future of Privacy Forum, an organization that serves as a catalyst for privacy leadership and scholarship. And today with this webinar, we officially celebrate the start of our partnership. And as Gabriela will explain, introducing panel one, a fantastic lineup of speakers, both from national data protection authorities and industry representatives, will discuss about the role of the data protection officer, starting from an analysis of a recent decision adopted in April 2020 by the Belgian regulator on this topic. So, heartfelt thanks to the colleagues of Future of Privacy Forum, DCU, the ADAPT Center, and the Irish Computer Society for their help in organizing and supporting this event. Thank you very much.
Gabriela, I think I hand over to you. For those of you who know Rob Van Eyck, Rob is our managing director for Europe. Gabriela is our senior counsel and helps lead our global engagement and global legal and policy thinking. So, Gabriela.
Thank you very much, Jules, and good morning, and good afternoon, everyone, because we have viewers logging in from both sides of the Atlantic, but also from Africa, I see in the chat. Welcome, and thank you so much for joining us. Our guests today for the first panel are regulators from different states of the European Union. They are called upon to enforce the obligations of the General Data Protection Regulation. Please welcome MB Donnelly, Assistant Commissioner, Data Protection Commission, Ireland, Daniela Havlikova, who is an expert for the legislation unit at the Office for Personal Data Protection in the Czech Republic, Hielke Hijmans, who is the chairman of the Litigation Chamber and a member of the Board of Directors at the Privacy Commission of Belgium, and Grégoire Delette, who is legal advisor for the DPOs department at the Directorate of Compliance at the CNIL, the French Data Protection Authority. We will have about half an hour of interventions from our guests, and we'll leave about 10 minutes for questions and answers. So go ahead and leave your questions in the chat box as you hear us speaking, or in the Q&A queue. I will first set the scene, even though Jules already did that a bit, but I would like to remind everyone that the obligation in the GDPR to appoint a data protection officer in certain cases was new for most of the member states, but not for all. So for example, we know Germany already had a tradition in this sense. The GDPR requires that the DPO be independent, that he or she reports directly to the highest management level of an organization, and that he or she is involved properly and in a timely manner in all issues related to the processing of personal data. The GDPR also specifically provides that an organization can appoint a DPO that also has another role in the same organization, as long as there is no conflict of interest between any other roles that this person might have and the DPO function. Speaking of which, the GDPR also lays out the core functions of the DPO, which are to inform and advise the organization and its employees involved in data processing about their GDPR obligations, as well as to monitor compliance with the GDPR. And I did the air quotes because I was quoting from the provision. Now, we've already seen a couple of cases coming from DPAs that enforce this particular provisions of the GDPR, and some of which found the role of the DPO was in conflict of interest with either the role of head of IT, and that's a case coming from Germany, as well as with the role of the head of compliance, audit, and risk department. And this is a case coming from Belgium. And Hielke will walk us a bit more into the argumentation in that case. And now the question, and we will start the discussion, taking all the requirements of the GDPR into account, right? So independence, reporting to the highest management level, being involved from early stages in advising on data processing. What makes a DPO to be most effective? How senior a role in an organization should a DPO have? If it's permissible to have other hats within the company, should only regular employees, as opposed to higher management or even middle management, be allowed to be a part-time DPO? Now let's hear from our guests, and let's start with MB, who is in a way also the host, from Dublin. MB, how would you weigh in on these questions, given your experience of working together with the DPOs in Ireland? And we know there are many DPOs in Ireland.
Well, first of all, Gabriela, may I say, and to the other panelists, thank you for inviting me to join you this afternoon or this morning or this evening. Please delete as appropriate for the relative time zones. And it is wonderful, Edoardo, to be able to be part of this initiative, this early stage webinar that you drew our attention to previously. I think, Gabriela, if I may just pivot back to the question there which you asked in terms of what is it that makes an effective DPO? And I think there are many layers within this, because it will hardly come as a surprise to anybody operating within the regulatory sphere that there has been in the past 2 years, in many ways, a sense of reaching for an appropriate qualification. What is this appropriate qualification that enables a person to be a DPO? And as you know, the text of the GDPR itself specifically veers away from that. It doesn't quantify in that way what you need. And that has been both that latitude that exists within the text of the GDPR itself is both an onus on data controllers and in itself a gift to data controllers, because it allows you as the head of the organization to determine what it is for your organization needs. Obviously, an appropriate and thorough knowledge of data protection law itself is a given, but what an organization can only quantify for themselves is a person who is appropriately informed as to the processing activities of that organization. And I think that is really crux. The DPO must understand not just the law, but what its own organization actually does. The data that it holds, the data that it processes, how that is moved through an organization, the reasoning behind why it is held and processed. And that is someone with a thorough knowledge within the organization. It's not a qualification that you can quantify on paper, but it is something that an effective DPO must be possessed of. And equally within that, I think it's reasonable to say that that same DPO must also have excellent communication skills and quite a high degree of personal integrity, so that their means of communicating this message outwards to the other key stakeholders within their organization in order to ensure buy-in and to ensure that the message lands is communicated effectively, and that that integrity exists where that role of critical friend is seen most effectively. That, I think, is where we have seen DPOs operate in their most effective way.
Thank you so much for that, NB. I will move now to Daniela, and indeed the Czech Republic is one of the countries that did not have an obligation to appoint a DPO prior to the GDPR. And I'm wondering, how has the landscape been over there? Have you seen many DPOs being appointed? Where do you see them in the organization? Are they indeed somewhere at the highest management level, reporting to the highest management level? Also, do you see many situations where the same person performs the function of a DPO and another function within the organization? Daniela.
Okay, hi everyone, good afternoon. On behalf of the Czech DPA, I would like to say that we conducted a few seminars where, according to our estimates, there have been 16,500 DPOs in the Czech Republic together, but it's the figure from last year, so I don't have the newest number. So that might respond to your first question. When it comes to DPOs in companies, so it differs. There are certain companies that use external services. There are certain companies that are using internal DPOs, and it varies a lot. So we don't have any specific numbers or figures that would help you in this respect. Believe not.
Well, that's already very helpful. And have your how has the DPA have you provided some guidance on this specific to the Czech Republic?
Yeah. There is a special section devoted to data protection officers on our webpage. Unfortunately, not everything is in English, but usually to work as a DPO in Czech Republic, you need to speak proficient Czech. So that's the first thing. Also, we had organized few seminars during past 2 years, where we invited small companies, public data protection officers, because there is one of the national derogations when we adopted the GDPR was also for the public sector, where the DPOs are one of the obligation for controller. So in that respect, I'm wondering what other figures could be helpful to you, because yeah, could you maybe repeat the second question?
No, that already covered it. You know what?
Okay.
If you have specific resources for the DPOs over there, and whether there were some specific guidelines on this, you know, conflict of interest or anything like that. So
not specifically. In the Q&A on our webpage, there is a special section. We translated the EDPB or VP29 guidelines. It's in Czech, but we so far haven't got any specific case concerning DPO conflict of interest, and there was no fine so far in this respect.
well, thank you so much, Daniela. I will now go to Hielke. And Hielke, we've heard from MB that you know, an effective DPO should be an excellent communicator, should be very well acquainted with all of the processes in the organization. And you know, we've heard from Daniela that in the Czech Republic, there were no cases yet to look into the position of the DPO and into a conflict of interest of any sort. Now, the Belgian DPA actually let's say recently, you know, in the past couple of months, published this opinion that was very well read by the community of the DPOs, where you found, well, you in the sense of the DPA found that a person that had the role of head of compliance, risk, and audit in a very big telecom operator in Belgium, also had the role of the DPO, and there was a conflict of interest there. So can you tell us a bit about how you got to that conclusion? And we'll go from there. Thank you.
Hi, Gabriela, nice to see you, nice to do this again. We were surprised after this decision we made, this decision where we thought we say some things which are fairly obvious, but it led to a lot of reactions all over the world, also in Belgium itself, of course. And some of the reactions were very helpful. Some of it were also not completely understanding what we said. But let's say what we tried to say basically in our opinion, that the core of this DPO function is an advisory function to the highest management. So as been said before, it should be someone, a DPO should have access to the management, should be a senior leader in an organization, should know this organization, so not someone from the outside. That's for us was very important. But at the same time, an advisor means an advisor and should have a certain distance to the day-to-day decision-making process. What we found in this specific case was that the data protection officer in this case was at the same time head of risk, head of compliance, head of audit, and was basically the main person responsible for all the processing operations. So basically the advisory function meant that he advised on his own activities to the highest management. There we said that's not the way it should function. However, what we did not do, because there were a lot of reactions, part of them saying, well, if you do what you do, you need an external DPO, you need someone from outside. I think that's exactly what I would never defend. It's the DPO, and that's what my experience is also from years before, is that the DPO should be a person of confidence within an organization, someone who knows the organization, should have all these qualities my Irish colleague already said, which is probably too much to have in one person. So usually you have it in a team. But the main point for me is that it should be someone who knows an organization, but should be a bit of distance of the day-to-day decision-making process to look at it afresh, and also be someone who can advise, can also be someone who can be a person of confidence for persons in an organization who have problems with data processing operation, because staff members who have complaints, etc., etc. So it's this role we see. Of course, for a DPA, that protection officer is a logical liaison, but I wouldn't see the DPO as someone as the long arm of the authority either. It should be someone from the inside with a certain autonomy, and that's the way I think, the way the GDPR proposed it.
Gabriela, I wonder if I might jump in, and Hielke, thank you. I think one of the reasons there was perhaps, some, I wouldn't say surprise, but, bigger interest than, of course, obvious, is I do think that there's an interesting question that many senior privacy experts, lawyers, executives, DPOs in companies maybe aren't fully clear on, and we're looking to see whether this decision is giving them some direction. So when you see there's a clear conflict, how could you be giving advice to the audit data that you are also doing the audit, and you're also determining, is this done in a GDPR compliant way? So you see, the obvious conflict. What about the people who are privacy advisors, chief privacy officers, privacy lawyers, and they're playing a senior role because they are senior executives reporting in at a very senior level? Maybe they have staff, they have teams. We know that in some companies, they took the DPO role, and some regulators said, great, this is the person we know they are playing a big role in giving advice, they're experts, of course they should be the DPO. Other companies said, no, this is a very managerial role. This is somebody with, legal management. Maybe it's a general counsel, maybe it's a deputy general counsel. So yes, they are very well respected and they're the biggest privacy expert in the company. But is the fact that they have these, management type advice responsibilities, is that creating perhaps the conflict? And so I wonder your reaction, because I think people were looking to, this is a senior person who seems to have, not a business role, audits and so forth, things that seem to be on the compliance side, and this was clearly a problem. What's your, is there a careful reading there that this case gives guidance in that area, or this case doesn't really tell us about that? It really is narrower because of the facts of the case.
The case was maybe narrower, but the way we explain it is probably a bit wider. I think it's important for a DPO to be an expert, at least an expertise in its team. It's also important to have sort of managerial role, not in the sense of deciding, but in the sense of being someone who is respected in an organization, who people listen to. What I see as the main DPO is someone in an organization who helps develop a DNA, a culture in an organization towards better privacy. I think that's not what we said in our it's not the core of our decision, but that's how I always look at it. It's privacy should be part of the DNA of organizations. They should be data processing, they should see that as something logical, something they want to do, not just a burden they have to do. So in that context, I think it's the expert, but also the expert who understands the context, who understands the organization, who should be someone from the inside. So I definitely think this is how I would advise organizations to have a DPO, someone who develops expertise, but not just as a free-flowing expert somewhere in an organization, but someone having real influence. I think that's what I would advise. But that's not exactly all what I say in my organization. Yeah.
Can they have too much influence, I think, is the concern for some, right?
I'm sure that people think, but I'm sure you're not one of them, Jules.
No, but I mean too much influence that they become not independent, not too much influence that they do their job well, but too much influence because they are the chief privacy lawyer inside the company. Is that create attention? They're managing.
Well, not necessarily, but I think it is good especially in a bigger company, if you have the resources, not to have everything centralized in one place. It's good to have privacy, I think. But of course, you need to have a bigger company, a company which has the resources for it, to have privacy experts at different fields, and they don't all have to report to DPO. They can have their own views, their own ways. They do their own work. So it's not a centralized Moloch bureaucratic thing. That's how I see it, at least.
Thank you.
Thank you very much. This was a very interesting exchange, and I will now go to Grégoire. And you are working with many, many DPOs on a daily basis, given your particular position at the French DPA. Have you encountered any of the conflict of interest situations? Can you share us something from your experience with this? I also see a couple of questions in the chat coming. Someone was asking about whether a safeguarding officer would be theoretically in a conflict of interest or not. Tell us a bit about what's happening in France.
Okay, with regards to what positions can or cannot be a DPO, I would say that it also goes back to that central principle that is accountability, right? And in the Belgian decision, you can read that actually the main problem that the Belgian found was that there was no proof that there was no conflict of interest. I don't think the Belgian wanted to introduce a new obligation in the sense that nobody in middle management or higher management can be a DPO. What they just say what was already in the guidelines, actually. That is to say that if you determine the means or the purposes of a process, then you are at a conflict of interest. And it's the role of the company to prove to the DPA that there's no such conflict of interest. But with regards to the questions of influence and how much influential the DPO can be, I think the DPO absolutely can be influential. I think he should, even if he wants to be truly effective. And he has to have that capacity to, both by training in general and also by answering questions on specific processing, he has to have that capacity to explain the bigger picture of privacy and data protection, and to be able to direct the processes in a certain way. So there is a tension in the sense that he must have influence, but he must also not determine the means and purposes. Yeah.
Well, thank you for that. Let's go back to MB. MB, there is some discussion in the chat of whether a DPO has to be a lawyer or does not have to be a lawyer, and how would that work, in practice, and where you have a big legal department, for example, in some organizations that might start talking to the DPO and speaking different languages, let's say. What are you seeing?
I think it's worth bearing in mind, again, going back to the original text of the GDPR itself, that a conscious decision was clearly made that in the drafting stage not to specify a lawyer as a prerequisite, but there is certainly no doubt that legal training provides a specific set of skills that many may find an attribute within the role of the DPO. But it does go back to the needs of the organization. And that is what determines what the fit of a DPO is for any organization. And we've all, in our various contributions here, come back to that same idea. It is the knowledge of the processing activities. It is the means by which to communicate that. And it is what is necessary and appropriate to the organization in question.
Absolutely. And I see also in the chat that there is a current investigation into the independence of DPOs in a public body. Someone is asking, what is the status of that? And then maybe if we can attach to this the role of the independence of the DPO and what does that mean, MB, and then we'll go to the other panelists on independence as well.
Yeah, sure. So the Irish DPA does have an investigation open at the moment into the independence of a DPO in a public sector body, and that is it's fairly well progressed at this stage. Is where I would term that in its lifespan. It is quite well progressed, and we will be hearing more on that in the near future. And it is to do again with the independence of a DPO, as you say, acting within their role. So. It not necessarily, I suppose, the conflict of interest, but the timely involvement, in the decision-making process, which is something else that is essential to the DPO role itself.
Yeah, absolutely. And Hielke, I know that this was also part of the case that that we just discussed, the timely involvement of the DPO in the decision-making process, and how that is important for privacy by design, well, data protection by design, Article 25. Can you tell us a bit more about that, Hielke? How are you seeing this? How early should the DPO be involved in hearing about plans of new processing?
I think about early involvement is a sort of basic starting point, and I don't think you can say this stage is always the case. It depends on what the issue is. I think if a company or public organization is putting in place a completely new processing operation, putting new management structure, IT management structure, I think then it's useful to be involved in an early stage. In other cases, it can be later, but the idea, I think, is better, as I see it, always better too early than too late, because if a decision-making process is already going on, it's better, then it's difficult to change the direction. On the other hand, so it's better to be early. On the other hand, what I saw it also as a legal advisor to governments, for instance, there must be something to advise on. There must be some thinking done. So it depends from case to case, but I would say in general, better earlier than later. That would be my thing. But you cannot say just early, just like this. I think the other point, which was maybe part of your reflection as well, independence is important, but independence is there for a reason, namely to be effective and do effective data protection, and not to be independent just as such.
Thank you, Hielke. Gregoire, we have a question here asking about how important is for the DPO to be not just the voice of compliance, but also the voice of the data subject internally. How are you seeing this issue?
There is this tension in the role of the DPO that he has to be part of the organization, loyal to the organization, and still be the point of contact with the data subject and the DPA. But I think one interesting trend that we see in Europe with regards to that, and we see that in the Belgian decision, but also in the German decision that said that the organization cannot open the mail of the DPO, is that the DPO is now seen as the function of trust, where data subjects must be able to trust that whatever they say to the DPO will be used in a specific way and not used against them, and in particular if they are employees of the organization. So I think in the recent case law, that's a trend that we have seen, that indeed puts the DPO in the place of being a voice of a data subject. But I would say more generally, the DPO has to keep in mind every voices of every stakeholder, the company, the DPA, the data subjects, and that's why it's such a difficult but fascinating role, I think.
Absolutely, and thank you for that. We have a string of questions that look into the parallel between a DPO and a CPO. Now, for the entire audience who might not be aware of what a CPO is, that's a Chief Privacy Officer, and that's a job that, for example, Jules is quite familiarized with because it appeared here in the US maybe 20 years ago or so. And the Chief Privacy Officer is someone that sometimes sits in the board, right? Or most of the time, all of the time. And that is very, very involved in data governance and the policy of privacy for the organization as well. So have you, any of you, did you give some thought about the difference between a CPO and a DPO, and whether a CPO can also be a DPO of a company? And my guess is that Ireland is seeing that more often than others due to the fact that there are so many headquarters, European headquarters of American companies there. So Andy, have you given some thought to this? And then if any of the other panelists would like to weigh in, that would be great.
To just look at, in terms of that, I suppose it's worth calling out that Ireland is one of those countries for which the GDPR introduced a data protection officer as a new requirement, unlike our German counterparts, for example, where the role in a various format had been in existence for a period of time. I can say that I was quite interested to listen to my colleague Daniela's figures earlier in the conversation, where you mentioned, I think it was in excess of 16,000 DPOs that are registered with the Czech Data Protection Authority. And I can say that for Ireland up until Friday, last Friday, the figure for here was 1,856 DPOs registered across all sectors, and the majority of which are private sector DPOs. And what that has indicated to us, and we have a new period of activity that's about to commence, in which we will be analysing and assessing those DPO notifications in particular, looking specifically, I suppose, at those bodies where a DPO should have been notified to us and has not been notified to us, or indeed where a DPO has been notified to us, but that their details have not been published on the relevant organisation's website in accordance with the prescriptions of the GDPR. And I imagine at that point that will also be the crossing area where we're encountering that thought between, is there actually a chief privacy officer who's also in the role of a data protection officer, and where that might lead us into what points of conflict. But at the moment, we just have DPOs working in on us.
That's very interesting. And this goes to a question that we actually have in the Q&A queue. And the question says that as a DPO, you are required to maintain confidentiality. If you are the CPO of a company as well, or in any other capacity representing the controller, how do you credibly deal with confidential elements of issues raised by data subjects with the DPO? And this also goes back to what we've discussed with Grégoire on how the DPO should also be the voice of data subjects within the company. Hielke, do you have any thoughts on that, on this particular issue?
Yeah, well, I think if you look at the GDPR, they try to make a sheep with 5 legs. I think, I don't know if that's good English, that's how we say it in Holland in any case, or in Belgium. So there must be someone who is at the same time the friend of the advisor to the highest management, at the same time the person of confidentiality to all the staff, at the same time being the confidential person for the regulator. So it's a lot basically what the GDPR has in mind. I think that it's important that, and that's part of this sort of status of independence, what the GDPR gives. The main part of this independent part is that as a DPO you are protected. If someone comes to you, complains to you, you keep your things confidential. You don't share your information, which you have as a confidentiality. And I think this confidentiality issue is the main reason why there is this protection of the DPO. So I find it very important. I wouldn't say that because of the reason to be confidential, you cannot at the same time be a chief privacy officer in another context. I wouldn't say that, but it's the main important thing is that you have a certain protection as a DPO in order to keep your mouth shut when things are asked. I hope that's an answer to the question.
Thank you, Hielke. I see some of our attendees are raising the issue of certification here in the Q&A. And this is perhaps something that should go to Grégoire, because I know that the CNIL has a certification or approved a certification scheme for DPOs, whereas that's not the case for most of the other DPAs, most of the other countries. And it should also be pointed out that the GDPR itself speaks of certifying EU level processes rather than persons. Grégoire, can you give us a bit of context about that certification program and how is it working? Because it's already been at least 1 year, I think, since it's available.
Absolutely. I have to be precise and say that the certification scheme is based on our national law and not on the GDPR. So that might explain why it's not feasible in every country. But it's been 1 year, nearly 1 year since we've implemented it, and it has been it has proved successful in the goal that it had, which was to give data processors and controllers some indications of who they maybe could hire if they want to find somebody who is not a self-appointed expert, you know, which we have seen a lot of not only fakes and scams, but also people who are pretending to be GDPR experts when in reality they were not. So it's mostly useful for external DPOs, I would say. But some internal DPO also have applied and obtained the certification. And most of the time it's an issue of legitimacy. They want to improve their effectiveness by showing that they are indeed an expert in their field. And I think that's one of the main things that a DPA can do for DPOs, and it's to put them in a position where they are unavoidable, and that if you want to have an answer on a data protection issue, you go to them. That's why, for instance, in another thing that our department did was to create a DPIA software, free tool that's on our website. And at a certain stage, if you want to continue to do the DPIA, you have to obtain the DPO advice. There's simply no way you can progress if you don't get the DPO advice and approval at that point. So I think it's one of the things that a DPA can do, yeah, certification and other things to make DPO's life easier.
Thank you so much, Grégoire, for that. I know certification is one of the big topics generally with regard to the GDPR. Well, we have about 1 minute left in our part of the discussion here. And I was wondering, you know, maybe if all of the panelists can give us 1 word or 2 words on what makes the DPO being most effective. MB.
Thank you for bouncing back up to me there with the think time. But I go back to knowledge of the workings of their organization. Key attribute of a DPO.
Yeah. Daniela.
Yeah, I agree with MB, but in general, I would like to say that having all the DPOs, the data protection environment in our country really improved a lot. You can see the difference.
Very good to hear. Hielke.
1 word, privacy leaders.
I like that. And Grégoire.
To add up to what has already been said, I would say it needs visibility, especially internal visibility.
That's fantastic. Thank you so much for this discussion. You know, I wish it went longer, and I'm sure we would have had a lot more to discuss. But now it's time to pass the microphone to my colleague Rob Van Eyck, who is going to lead the second session of our program today. And thank you to our panelists. This was great. Thank you so much.
Thank you all.
Thank you, Gabriela.
And we'll do our best to get to some of the questions either in the next panel or we've got them saved here, and we'll try to either respond or ask for some expertise if we don't have it to communicate some of the answers to the broader group. I'm just looking at many of the names, and it's experts from around the world, and if they have questions, it's the kind of question that probably many other have. So we'll look forward to trying to help get some good answers. Thank you all. Edoardo, thank you.
Thank you, Gabriela. What we'll do is we're going to bring our panelists in from the second panel. So this may take a few moments, and Nicole is busy doing that. We had very interesting questions already. It's time to bring in the DPOs, and I'm going to co-moderate this with Edoardo Celeste. And maybe in the meantime, you can make a quick introduction of our panelists, Edoardo.
Yes, thank you very much, Rob. So in this second panel, we will have Mary Murphy from Fort Privacy and the Association of Data Protection Officers Ireland, Mark Crosbie, Data Protection Officer at Dropbox, Damien Kieran, DPO at Twitter, and Udo Oelen, Chief Privacy Officer at Dutch Railways. So I'm waiting for a minute to see whether our panelists have joined the webinar. Okay, I see Mary. Hi, Mary.
Hello.
Perfect.
Hello.
While I wait that maybe like the other panelist, I think that Nicole is joining the other panelists to the webinar, I will immediately start with a question for Mary. So we decided to organize actually this webinar in light of a decision adopted by the Belgian Data Protection Authority on the role and the potential conflict of interest of a data protection officer. And Gabriela actually prepared an excellent summary of the decision, which perfectly aligns that the decision focuses essentially on two aspects. On the one hand, the aspect of the involvement, and in particular in this case, the insufficient involvement of the DPO in the decision related, of course, to data protection within the company, and on the other end, the aspect of the conflict of interest. So it seems to me that there is a clear tension between involvement of the DPO on the one hand, so companies would like to integrate the DPO really like in the stage of product development, and on the other end, there is the question of the conflict of interest. So my question is, in your opinion, how can we reconcile this tension?
Okay, that's actually a nice, challenging question to start with. I think we have to be clear about what type of involvement you have with the DPO has in, say, in a process. So if you're thinking about something like a new product development, if the DPO is involved in a consultative role, involved as early as possible for the purposes of the DPIA and for the purposes of making, helping to advise on key data protection conflicts that might come up, or key data protection discussions that might come up in the product design. But they're not a decision maker in terms of the end product. I think that's where you get rid of the conflict of interest. I think you have to be very clear. The DPO needs to know what's going on. The DPO needs to be able to give advice. The DPO needs to be able to understand what the scope of the product is, what the potential data protection risks that are being unearthed are. And in order to do that, they need to understand what's going on, so they need to be involved, but they don't need to be a decision maker in the process. And if you can separate that involvement from the decision making aspect, then I think you can maintain that independence and you can avoid conflict of interest.
Many thanks, Mari. So, Mark, Mari rightly highlighted the point of involvement in the decision making. So, for you, what are the boundaries of conflict of interest for a DPO? And if you have any practical example that may suggest that these boundaries effectively work?
Yeah, thanks, Edoardo. I think Mary kind of outlined it fairly well, and that you, on the one hand, as a DPO, you can't live in an ivory tower and emerge every so often like Gandalf to like dispense wisdom. You have to be down in the trenches at times to really understand what's going on, because you will always find the devil in the details, and the thing that pops out of left field is the one that you really need to be paying attention to. And it's often not the one that you think the company is bringing to you. You might have to poke and prod a little bit, ask some very awkward questions, and maybe get into a little bit of trouble every now and then just to unearth what exactly is going on. And I think that gets to what some of the previous speakers said, and also some of the questions I see in the chat here around, how does the DPO stay on top of what's going on given the size and scale of processing? The way I like to phrase somebody there used earlier was a critical friend. I like to nudge people in the right direction. I like to say, okay, you're doing that. Sounds interesting. How about we do it this way? Sounds good. Let's do it this way instead. Just nudging them towards a better outcome for the ultimate product itself, but also more importantly for the data subjects who are going to be using the product. Because I kind of see the metric. I was asked once, like, what are the KPIs for an effective DPO? There's no number I could think of, but ultimately a DPO wants to drive change. If you're not making change happen in your org, you're just a talking head, really. And I hope I'm not that in Dropbox. So what I'm trying to do is ultimately get the company to make a change in how it's go about doing something. Now, it's great if they've everything already figured out ahead of time, but if I can nudge them towards that change, I think that's where I'm being most effective. Where I don't think is appropriate and where I draw the line and have drawn the line in the past is when someone comes to me and says, Mark, do you approve this? And I draw the line there, because the moment you say to me, Mark, as DPO, do you approve this? I'm deciding on the processing that's taking place. And that's trigger word I look out for in a lot of conversations. I'm quite senior in the org. I'm lucky enough to have a very senior role. So by default, most people look up to a senior person as a decision maker. It's the natural flow of decisions in a company. They're quite surprised when a senior person turns around and says, no, sorry, I don't decide. I don't approve. You decide. It's on your head, be it. I'll advise you and guide you and explain the consequences if you get it wrong. But you, executive, must ultimately own this decision.
Thanks, Mark. Thanks. And this is indeed an aspect that also the Belgian DPA actually dealt with in its decision. So what is therefore the requirements in terms of involvement of the DPO as well? So the DPO, and this is a question for Damien, the DPO should be, of course, independent, should not interfere in decision related to the means and the processing itself, but at the same time should be involved to a certain extent. So where is where to draw the line between these two, involvement and independence of the DPO?
So I think I take the view that involvement early and often is very critically important. I'm not sure that I necessarily see a conflict between early involvement and independence. I think it depends on how you structure the organization. And I think every organization, every company is its own special sort of animal. I think that at Twitter, what we've tried to do is we've tried to embed sort of a culture of privacy and data protection over the last 2.5 years, 3 years, where the sort of engineering product folks are consulting with the appropriate members of both the Office of Data Protection, product council teams, to get the different viewpoints that they need. So a very collaborative and consultative process. I think where maybe more of the challenges come is that, to use something that, to key off something Mark was saying, is when folks come and say, do you approve? I think approval can also be like a sort of a magic word for when folks go to lawyers, because they want to know that, is the lawyer okay, right? Or is the sort of the compliance person okay? And so I have found that in many instances, the word approval doesn't necessarily mean they're looking for you to sign off on a product, but does this meet your threshold? Is this a thing that you take issue with? So I think getting hung up on specific words can be a little bit challenging. What we've tried to do though is build processes to enable us to meet the independence requirements and enable the org to get the consultation early. So we do a privacy review very early, as soon as an idea is loosely baked. It may not be finally baked, but loosely baked, to understand whether we're going to need to be heavily involved throughout sort of the life cycle of the design and build of the product. So we've tried to operationalize as many of these things as we can. It's not always easy, but that's been the approach.
Many thanks, Damien. And you mentioned the aspect of the structure as well. And I wanted to ask Udo to intervene on this. Gabriela in the previous panel mentioned the distinction between the CPO, the Chief Privacy Officer, and the DPO. So you currently work for the Dutch Railways, but you were former head of the private sector of the Dutch Data Protection Authority. So should we really need a sort of like a separation, two separate roles, a sort of like Chief Privacy Officer more involved in the phase of like a business and the product development, and the DPO who would have a more independent and separate role?
Well, it wouldn't be very wise if I would advise that, because I'm not only the Chief Privacy Officer of Dutch Railways, but I'm also the Data Protection Officer of Dutch Railways. So I was really very anxious what Hielke told in the previous panel on that topic. What I think is that you can combine that role. Actually, when I started about 2 years ago at Dutch Railways. There was a discussion on the question if you should separate the role of Chief Privacy Officer apart from the role of Data Protection Officer. And I believed in that at that point, and I still believe that that some organizations, I won't say every organization, but some organizations, it is good to combine those two roles, because I think a Chief Privacy Officer is the leader who should implement the privacy policy, has to implement privacy controls, have to manage a team of privacy officers in the organization, and the DPO should have well to look if the GDPR is handled properly. And I think if you work in an organization which is, well, when I started at Dutch Railways, is not that mature in handling data protection questions, I think it's very wise to combine that role. Otherwise, you can come into a situation where a Chief Privacy Officer with his privacy organization says, okay, you have to handle this this way or that way, and in an other stadium, the DPO says, no, this is not the way you should do it because you are handling in conflict with the GDPR. So I think combining these two roles can work in an organization, but I am aware of the fact that when I put on my hat of a data protection officer, that means something. It means, and it also means in my role of Chief Privacy Officer, that I am not involved on a first-line basis in advising the business on what to do. It is my team who advises the business on a second line, and I will coach them and control them in their advices. So I think also in my role as a Chief Privacy Officer and as DPO, I can look with a certain distance to the way Dutch Railways will process data, and can overlook if it's if Dutch Railways does it on the right way. And I think a DPO should also take into account if the measures which were advised, for instance, when the DPO advised on the data protection impact assessment, and if there were measures advised, the DPO should also check later on if those measures are implemented. And the DPO can also, if by itself or using audits, look after if all the processing of data are in line with the GDPR. So again, I think the roles can be combined, but you have to be aware of the fact that then you are dealing with two second roles.
Edoardo, I wonder if I might interject an interesting thing that I've seen a few times in the chat. Evidently, some companies have a head of product, or a few people have asked, what about the head of this sort of operations? And my initial reaction was, that's exactly the people who are determining the means and the control, and that we might quibble about whether you could structure IT or compliance in a way that somebody in that department is or isn't, and maybe that's why the Belgian decision was sort of interesting, because it seems like removed from means in processing, but of course it was clearly a problem in that case. Do you all agree that that's that would be a blatant no, even though that person might be the voice of the consumer, might be the chief make good products that the people like, evangelist, but that they are determining the means. So product lead or business operations type leads. Is that a pretty clear no from any of you who have a reaction on that?
Yeah, I actually, can I jump in there, because I used to be a product manager, so I used to have that role, and I know the conflicts that you can have as a product manager, just juggling your customers versus schedules and to add into the mix the role of the DPO, I think would be quite dangerous. And I think the product manager ultimately is trying to get products out the door. And they're going to be under quite a lot of pressure, for instance, from scheduling pressure in terms of what goes into the product, what the budget for the product development is, you know, how soon can we get this new feature out the door? And as the DPO, you're trying to avoid any shortcuts being taken when it comes to processing personal data. And I think that's where the conflict can arise, because you've got two opposing horses pulling you in different directions there.
Yeah, I think I saw the others all nodding firmly that would exactly be a good example of somebody who couldn't be the DPO.
They couldn't be the DPO, but they could. Sorry, I was just going to say they could also be the best friend of the DPO, though, because if you cultivate those relationships, or to Damien's excellent point, you structure yourself out of a job, which is how I like to approach it, which is basically build the structures, build the processes, make it inevitable that the right thing happens. And you know what? You don't have to. You can live here in the Maldives all day, right? Basically, though, your goal here is to develop that relationship with these product managers, directors of product VPs, so they're not afraid to come to you for advice. They know that you're going to steer them in the right direction. You're not going to put some extreme measures that will delay their release by 6 weeks and get them fired. You're there to help them be better at building a product. And I find that then helps you have eyes and ears. I don't mean in terms of spine, but just that awareness spread out across the organization. The amount of coffees I've drunk with people like that, and you learn so much, that just flow of information, I think it's critical to be an effective DPO. Many
thanks, Mark. Your reaction, Damien?
Yeah, so I'm going to just try and challenge it just for the sake of challenging it from the other side, because I fundamentally agree with both Mark, Marie, and Jules, but I do wonder whether there is an effective way to do it. That is to say, so it's one thing to, for example, actually be the head of a product team and be the DPO. That's like, I think, impossible, because you are literally making the call about a product that's going to go out the door. But having someone that is the DPO or CPO that represents consumer voices, that is within that org, just as an organizational matter, doesn't necessarily present a problem, provided that person is given the independence and freedoms to deliver the opinions that they need to provide, and it's respected by the appropriate leadership. So it becomes a question of organizational structure over actual independence and conflict of interest. So, you know, I think many of us are familiar with, obviously, the FTC's decision last year, and, you know, Facebook has taken the decision to put sort of their CPO of product in their product org. And I could see a way in which that works, provided that person is given the independence to deliver the guidance and the opinions that they need to provide. And I can actually see a benefit in doing that on the other side, to Mark's point, because then they are so embedded within the team, they are a colleague, they share all that information. So I don't think it's impossible. I do think it presents some difficulties, but yeah.
Many thanks, Damien. And Rob, I think that I see that there were a series of questions concerning the feasibility of this combination and the structure, the division between CPO and DPO. Do you want to ask a follow-up question to one of our panelists?
Yes, thank you. I have a follow-up question to Udo. And it seems to what extent do you have support for your position? For instance, if you give an advice to a product manager and your advice is a clear no, to what extent can that advice be overruled, and basically how is this embedded in the organization?
So we have our governance, our policy, and there is also a DPO charter. And it says, if the DPO says no, it is no. But at the end of the day, of course, our board of directors is responsible for Dutch Railways. So if the business says yes and I say no, because I think that will be too big a risk in compliance, then we go together to the board of directors, and then the board of directors can balance all the yes and the no's, and how big is the business opportunity versus the compliance risk, and then the board of directors should make the decision. I think that's how it should work, because the board of directors is at the end of the day responsible for the whole organization, and also working compliant with GDPR or other legislation. But
Mary, do you see this as well?
To finish it, if I say no, the processing of data can't be started. Then we have to go to the board of directors first. So a product owner can't start the processes if I say no.
So it's clear we hear that a clear intervention by the CPO/DPO does have value. And it's clearly embedded in the Rich Railway organization as well. So Mary, do you see this across the board, the data protection officers as well in Ireland?
Yeah, and actually I'm in an interesting position because our company does outsource DPO. So we're DPO to a number of organizations, and we have to put, I think, additional controls because we're not present within the organization. We have an additional piece of work to do to make sure that we're involved in a timely manner. We probably have to care a little bit less about the independence, because by the nature of being outsourced, we are independent. We have to be careful in our contracts that we ensure that, of course. But one of the things that we put in place and we insist on with all of our clients is that we must have direct access to the board of directors. And that is precisely because if a conflict comes up, if we give some advice and the organization decides that they don't want to take our advice, we must have recourse to the board of directors in order to be able to resolve that conflict. And so it's something that we're very clear about, and we're very clear in all our contracts about that.
So
one question, rather than jump in with another, one interesting question that I see coming up that I really don't know the answer to. We see DPOs sometimes taking a lead role in implementing certain solutions, right? The cookie banners, or really kind of being almost the owner of a privacy by design, driven process where, they are the expert that is really saying, here's how to do it. But are they then responsible for checking their own work, right? If you give the guidance for how the cookie consent flow should work, are you being sort of forced to be the person determining the means of the processing of the data, because you're determining the legal structure that is shaping the product, right? Is there a really challenging line there to draw when the DPO is, empowered and has some tools and is, almost maybe not managing personal information, but playing a very strong role in guiding what the engineering and policy process is? Damien, you look like you had a...
Yeah, I think this is where the rubber meets the road on sort of the recent decision, but also sort of like to Marie's point, and this is meant we have the same challenges, but if the business ignores your opinion or your guidance, and then you have recourse to the board, what is that but a decision in any other way, right? What is that but an approval by any other means? And it's sort of like Udo's point of, you don't approve the processing, or they can't start the processing, and you go to the board. It's a decision. And it's sort of, at some point, I think there has to be a practical recognition of the way that we improve things for data subjects and for privacy and data protection. And when you have these senior leaders who are providing guidance on best practices for cookie banners, they are the appropriate people to be making those calls and decisions. But I do think that there's a certain amount of this that can be dealt with sort of by operational process. So the example I would give, it's a slight modification on what Udo was indicating, but we have situations where a product team will look for just general guidance or discussion. It's a chat, hasn't triggered a DPIA. Now, if we trigger a DPIA, we're in a formal process. We've done a privacy review. There may be a likelihood of a high risk to the rights and freedoms of an individual. We're now going to follow that process. In that context, we will have remediations potentially. And at that point, if the business does not want to do them, there is an escalation path to get to the board, right? So it's sort of dividing out those two things that is sort of just, hey, best practices versus like triggering the compliance side of the house. But I do think that taken to its logical conclusion, Jules, like, look, I have a team of people. My team has infrastructure that processes data for the purposes of doing our job. Who has to decide that? We're the Office of Data Protection. I mean, you can go down an absurd path, or we can be practically realistic about how this has to work.
Many thanks, Damien. Rob, do we have any other question from the chat?
No, I would like to hear Mark, before we continue, whether he recognizes this tension as well, and to what extent we can maybe learn how this is embedded within Dropbox.
The tension between the DPO and like making decisions on the processing and the advice to management.
And then specifically, if there's a no, and how that would be handled.
Yeah, so I generally think if I have to come in with a hard no on something, I've kind of failed earlier in the process, right? Like we shouldn't be at that point. It's strange if I listen to the this is like listening to this and looking at the chat. There almost seems to be this assumption of an antagonistic relationship between the DPO and the organization. But what if there's not? You know, what if that's not the model we want to aim for? And there is a skeptical but somewhat trusting relationship. You know, they're friends, but friends who question each other. And I think that actually might be the mental model to adopt here in some ways, because to me, this antagonistic relationship and some of the things we're describing here and some of the questions I'm seeing are almost indications of like a failure earlier in the process. Much like Damien was saying earlier, a lot of people are going to come to you just for a chat. Hey, Mark, how do I even think about this? What is the guidelines? Can you give me your best practice guide? What do I even need to think about? Because I want to do the right job. Now, you're going to sit down, you're going to advise, you're going to guide, you're going to like help that person in understanding the world of privacy, because you know, nominally you're the expert. Does that constitute giving advice? Well, I kind of like, you know, the DPO's role is also to be an educator and to be an evangelist for privacy, and I'd see that falling under that umbrella. But I think Damien put it well there, like there's a trigger point, right? And if that trigger point moves over into the formal process of a DPIA, where there's an assessment made, there's mitigations suggested, the way I always pitch this is, look, to the business, and I brief the CEO, I brief our executive staff very frequently on this. You are free to decide to do whatever you want to do. I am going to write my advice over here. You're going to go over there and you can read it. You can decide what you want to do. But it will be on your head if you decide to ignore it. And you better know what you're doing. If my advice is saying not do that, and it's written over here, but you decide to go a different route, because then the very next thing that's going to happen is that if there was ever an investigation, a DPA would ask, did you consult your DPO on this? What did your DPO say about this? Did you follow the advice of your DPO on this? And in those type of situations, you better have a very clear rationale put together of why you ignore the DPO's advice. I'm very happy to say that has never happened in Dropbox, and I really, really hope it never does, because that would be an indication of some terrible failure on both of our parts, mine and the executive management. But to me, that seems to be the right way of putting it, is like it gets away from making decisions, but it so clearly lays out the consequences of ignoring the advice of a DPO. Now, the organization might choose to do that, might have a very good reason to, or might feel it's worth the risk. That is fine. They are the executive decision makers who own it. But it's my position is to like document and prepare that advice for them in such a way that they can understand it, they can do something with it, and then they can choose whether or not to follow it.
And Mark, let me just point out for those, you cannot have a program about the DPO without a debate breaking out in the chat about whether the DPO really needs to be a lawyer, really should be a lawyer, can't conceivably function if they're not a lawyer, even though GDPR doesn't require that they be a lawyer. Can I just point out to the panelists that Mark is not a lawyer, comes with a senior technology and trust background at a global, respected company. And so let me ask you, Mark, how do you manage without a law degree? And I'm obviously tongue-in-cheek, because as a lawyer, the best chief privacy officers, with respect to our lawyer friends, the best chief privacy officers, in my experience, have been people with deep business understanding, deep technical understanding, who can read and learn and can rely, when it's really a matter of, creative legal nuance, on legal support. So can I point to you as an example of a successful non-lawyer? And are you hampered in your, you do deal obviously with complicated legal questions about cloud and data and so forth. How do you survive without a law degree?
How do I survive? It's been a rough life, Jules, a rough life. Yes, as Jill said, my background's computer science. I've done computer security for 20-something years before becoming a DPO. In some ways, that's armed me with a healthy skepticism. And so I do see a lot of questions about lawyer versus non-lawyer. I think a good DPO is a...
Sorry, I think that...
yeah. Oop, somebody muted me there. Shut up, Mark, they said. In some ways, the other thing is that I have a very strong legal team I can rely on. I am part of the legal organization. You know, I have to live somewhere in the org chart. I report to our chief legal officer, but you know, I rely on all of my colleagues in the legal org to do the heavyweight lifting of the legal analysis and and I'm always there to ask the awkward questions, and as others have said, to ask the questions from the point of view of what are our data subjects, our users going to think of this? What's their mental model when they're looking at this? So it certainly has always been in the back of my mind, I don't have a law degree, and I have to be extremely careful never to present myself as giving legal advice, because obviously I cannot do that. On the other hand, I've built and shipped code and products at scale, and I kind of know the dirty little secrets of what goes in the backdrop. And so when I'm in a meeting with engineers or product managers, it's pretty hard to pull the wool over my eyes. And I think to the first panel's point about knowing what's going on in the organization, I think that skill set is critical. So whereas I have to learn about the law and rely on my legal colleagues, I do have a stronger sense of the technical capabilities that are possible and what data can be processed and how.
Thank you very much, Mark. Coming back to the question of involvement and independence, I would have a follow-up question for the speakers, because so far we have understood that essentially consulting the DPO is key, but vice versa, from your point of view, is there any situation in which, for example, you don't participate, you don't attend meetings because you don't want you want to avoid, for example, a situation of conflict of interest, or you want to maintain your independence? Mary?
I honestly, I can't think of any, to tell you the truth. And I thought about this before the webinar. I think it's the more you know, the better. And I haven't yet come across a situation where I've been given knowledge that I felt I shouldn't have, or that I'm uncomfortable with. And I would work with many different organizations in different types of environments. And I cannot think of a situation where I would be in a meeting that I'm saying I need to excuse myself from because I'm finding out too much information here. I think knowledge is key for the DPO. And the only place that we would see a conflict of interest, maybe in meetings, would be where one of the things, and this is particularly because we're outsourced DPOs and we have that service, we're very careful that if we're working with a client, that we don't work and advise any of their data processors. So we're very careful that we can maintain that kind of independence, so that we're not giving advice on two sides of the same discussion. But that would be the only exception for me.
Mary, how can an outside DPO, and clearly, you know, many companies cannot afford, and some companies prefer, is there a challenge in being involved in some of the day-to-day product that you know, you hear you know, discussion of, you know, is an outsourced DPO only for a smaller company? There are obviously even bigger companies who see this as the most effective way to have someone independent, but can someone be fulfilling some of the monitoring and some of the levels of engagement that seem to be desired? I almost heard Hielke expressing like a big preference for, you know, somebody really being internal. Yep. It feels like there's still a tension here about how the external really works compared to the internal.
Yeah, and the way it works, really, it is the one big challenge for us, actually, is to make sure that we're involved all the time. But equally, I see internal DPOs not being involved appropriately, being left out. You know, so I think it's a challenge for DPOs across the board, not just the external DPOs, because even when you're in the company and you're there every day and you're visible, one of the challenges is that organizations will go off and do something with data. They'll set up a new service and they won't really think through the fact that they're processing personal data because they think too narrowly about what personal data is, or they're outsourcing the processing and they think, well, that's not our responsibility anymore. So they don't think through the implications of outsourcing it. So I've seen that you know, failure to involve a DPO, even where the DPO is internal to the company, being a challenge. It certainly is a challenge for us. How we do it is we create a privacy team or a data protection team within the company when we go in, and it's a very formal thing. We look for representation on that team from anybody in the company who's going to be influential in data processing. So for instance, HR, finance, you know, and the various roles within the company, operational roles within the company. And we see our role very much as that culture change role that a lot of people have talked about already, the other panelists have talked about. And very much what our role is about pushing data protection practice out to the edges of the organization. So getting that embedded into the thinking of the organization. And that's not an overnight job, that's a slow process. And it takes time, and it takes a lot of meetings and a lot of structure and a lot of activity with the data protection team. But the data protection team is key for us as the outsourced DPO for making those key relationships within the organization.
Many thanks, Mary. I just wanted to ask the reaction from Udo and Damien on this point, and ask all the speakers a final question. What is, in light of today's discussion, your best advice therefore for a DPO? Udo.
My best advice for a DPO, I think it's don't use the no word, because the no word is the way to disturb a good relationship. And I think, of course, at some time there is a no, but before you can use the no word, you have to made an intense tango with the business to look if there is possible a yes. So the no word is not a good word for a DPO. And I sometimes make the joke, well, I work now for Dutch Railways, and I don't want to use no word because when I worked at the Dutch Data Protection Authority, no was the word I used several times a day, and I've done that enough for all my life. So let's make it work because it can work almost always.
Many thanks, Udo. Damien, on this point.
Yeah, so I think, I don't know that I have one piece of advice. I think there's too many complicated issues in here to give one piece of advice. But I guess what I would say is that there was a piece in IAPP a number of months ago, and I think Carl Ryan from the IDPC gave a quote where he said something like, the DPO needs to be a person who is very strong in conviction, sticks to their guns, all of that good stuff. And I think that to me represents one of sort of the North Stars in how I try to do what I do. I try not to follow the bright lines of sort of getting embedded in, well, should it be done this way? Shouldn't it be done that way? If the North Star is doing the right things for data subjects and following that North Star in the best way you can and advising the business in the best way you can within the constraints that you have, I think you're going to improve things, which is ultimately my goal, my objective. And that's what I would encourage others to do.
Many thanks, Damien. Mark?
So to build on what Udo and Damien have said, and to really stretch Damien's analogy of North Star, as you're on that path to the North Star, you'll probably see things off to either side of the path you want to go dig in on and explore. And I think the role of the DPO is to be somewhat poking and prodding into the darker corners of things and not to be afraid to ask awkward questions. I also think that's what Carl Ryan meant about having that strong sense of conviction as to what's right. So not being afraid to ask the questions that senior people or parts of the business don't really want to have asked, and to not accept the first answer you're given. So to just keep digging and digging and being a little bit uncomfortable in a friendly way, but still you're looking for answers. So while you're walking towards that North Star, which I think is a wonderful way of putting it, don't be too blinded towards what's going off in the periphery of your vision in the organization.
Many thanks, Mark. Very helpful advice. Mari, your point on this?
I actually just think Mark said exactly. I was going to say, let's build. I agree with Udo. You must be approachable and not be the person who's always going to be seen as a blocker. But you have to be inquisitive, and you have to. If you see something kind of poking out from under a stone, you have to be willing to lift up that stone. You know. So just to reinforce what those two guys have said, it's right.
Many thanks, Mari. Very helpful advice. I don't know if Rob or Jules would like to say a couple of words or a last question before we close the webinar.
I think I'd like to point out that we had a very lively discussion today, not just in the panels, but also in the chat. There are more than 50 questions in the Q&A. So let me just wrap up and thank our speakers at the first panel, MB Donnelly, Daniela Havlikova, Hielke Hijmans, Grégoire Delette, but also the second panel, Mari, Udo, Damien and Mark. Thank you very, very, very much. I also want to point out that next week there is, of course, the important Court of Justice decision, which will be delivered on the long anticipated judgment of the Schrems 2 case. The following day, the Future of Privacy Forum will host a virtual conversation between Bruno Ganzarelli, head of the International Data Flows and Protection at the European Commission, and also Helen Dixon, Data Protection Commissioner for Ireland. It will be led by Gabriela and by Jules. So I'd like to invite you all for next July 17th for an expert discussion to hear what the court decides and what it means for transatlantic data flows and what companies and organizations should consider now. So almost on the clock, perhaps finishing 1 or 2 minutes early. But I'd like to thank all of you, and let's give it a wrap. Thank you very much, all.
Many thanks for joining us. Also on behalf of DCU, a couple of words to say thanks to the colleagues of Future of Privacy Forum. This was our first webinar, so we're starting to mark the start of our cooperation, our partnership, and we hope there will be many other webinars in the coming months as well. Thanks to my colleagues at DCU and also the other centers which supported this event, the ADAPT Center and the Irish Computer Society. Thank you very much to all the speakers as well.
Thank you.
Thank you.